Research Group, and this is the healthcare class action. And we are very pleased to have two speakers here. I'm going to just do a very brief introduction. Matt Cantor is a partner in the law firm of Constantine, Cannon, LLP, and not related to me. And it's almost amazing that you could have two Cantors on the same panel here.
That's true.
He's a well-recognized expert in antitrust litigation and counseling, including matters that specifically concern health services, financial services, telecommunications, and media industries. And he has substantial antitrust trial experience. And then Colin Kass is a partner in the litigation department and co-chair of Proskauer's antitrust group. His practice covers financial services, healthcare, sports, media, pharmaceuticals, and automotive markets, and spans the full range of antitrust and unfair competition-related litigation. And to start this session, we're going to have Matt do a brief overview of the class action structure. And we're just going to take a couple of minutes with that, and then we're going to do this as a question and answer with the panelists. Matt is actually going to more or less present the perspective from the plaintiffs, and then Colin is going to present the perspective from the defense. So go ahead, Matt.
Thanks, Robin. First of all, I have not reviewed Ancestry.com recently. Robin and I could be related. We may be related to Colin, too. We just don't know. Okay, but with that said, I am going to present the plaintiff's perspective today, but I do both plaintiffs and defense work. Plaintiff stuff's more fun to me, but I do think I have a sort of a dispassionate view of these issues. I am a heavily based antitrust lawyer. I'd say 90% of my portfolio is antitrust. I know that's the same for Colin as well, so a lot of what I'm going to be talking about today is in terms of antitrust. Also, I just wanted to talk about why this is an important topic. For those of you who don't know, in the United States, about 20 cents of every dollar is spent on healthcare. That leads to an environment which is rife for litigation. That is why we have so much healthcare litigation in this country between insurers and providers and between members of a plan and an insurance plan itself, between hospitals and physician groups. It's just quite rampant, frankly. And from that scenario, you have a significant amount of class action litigation. So Robin has asked me to discuss sort of the class action standards. For many of you, I can see you're class action lawyers, so this may be very elementary, so forgive me for that. Think about why we have class actions, and the reason why is very simple. It's to provide an environment where you can efficiently adjudicate whether particular practices or transactions are indeed illegal. Think about an insurance coverage dispute, whether a particular treatment should be covered by an insurance policy. That's something that's generally applicable to various insurance plan members, therefore leading to many ERISA lawsuits concerning the legality of that practice. The argument is that the plaintiffs would put forward, and I would put forward, and I would submit, is that to litigate that on a class action basis as opposed to on a piecemeal basis would be efficient and is better for our economy and better for the from the perspective of providing justice, which is what I think we're trying to do here. To certify a class action, as you may know, particularly under federal law, you have to satisfy, if you're a plaintiff, the 4 prerequisites of Rule 23A and one of the subsections of Rule 23B. The 23A subsections are simply listed as the first 4 prongs there. Does the class contain so many members that the numerosity prong is met? Generally, you need a couple of hundred class members to meet that prong. Does the action raise common issues? The courts are pretty legion in saying that as long as there's one common issue that's there, you're going to meet commonality. It is not a demanding test, unlike the predominant test, which we'll discuss in the context of Rule 23b3. Do the proposed class representatives have claims that are typical? that are similar, not necessarily identical, but similar to the absent class members. And here's a good point, a good place to talk about who are class representatives in healthcare disputes. Well, they may be entities that you wouldn't necessarily consider as being class action plaintiffs. Certainly you have individuals who are members of insurance plans that sue, that happens. But you have employers that sue, who are paying premiums on behalf of their workers. You have providers that sometimes sue, particularly when it comes to insurance policies. You have health insurers and self-funded plans that sue when there are anti-competitive actions or allegations of anti-competitive activity that have led to higher prices, for example, for a particular drug or pharmaceutical product. So really, various different types of entities can be class action plaintiffs. Finally, and we mentioned, I believe this was mentioned before, the fourth prong of Rule 23A is, are the proposed class action representatives adequate? Will they see the action till the end, and are there no conflicts between the class representatives and some significant subset of the class? Then again, as I said, so if you meet those prongs, you come to Rule 23B, and there's two significant Rule 23B subsections. There's a third one, but I'm not going to get into it. The first one is, has the defendant or defendants acted or refused to act in a manner that is generally the same towards the class members as a whole, warranting injunctive relief? Frankly, that's the less demanding of the prongs. The more significant prong that plaintiffs generally want to meet, because frankly it means for damages payouts and often means for high attorney fees as well if you're successful, is are there common issues that predominate over individual ones? And is the class action a superior mechanism for adjudicating the dispute? What does predominance mean? Well, that's something that I believe is viewed differently potentially in certain jurisdictions than others, but it generally means, from the standpoint of the Supreme Court in the Dukes case and in the Comcast case, that there must be some showing that there's a capability of demonstrating that the plaintiffs or the class members have been commonly impacted by the practice at issue. So you have to show at the certification stage that at trial you'll be able to present some type of mechanism demonstrating that the plaintiffs have been impacted, and we'll talk about this a bit more. I know Colin will have some thoughts on that as well, and that's often where the rub is.
So, Matt.
I know, I'm not showing all the slides.
Okay.
So in what context have class actions been brought? They've been brought by, I wanted to talk about this and then we're going to move on, medical providers. Medical providers have been plaintiffs in cases concerning medical providers, whether, for example, they've engaged in activities to raise price, that has been the subject of class actions. In the Seventh Circuit, there was a case called Mesner versus North Shore Evanston, which had to do with a merger and a post-merger price increase. In the state of California right now, there's a case against the Sutter Hospital System brought by self-funded plans, and in the federal court, there's a corollary there. I'm involved with the federal court case, so I'm not going to talk specifically about it, but it does concern provider practices. The class members in that case are fully insured members or subscribers that pay premiums to plans that have dealt with Sutter. In the pharmaceutical context, there have been employers, there have been self-funded plans, there have been fully insured plans that have brought class action cases concerning so-called reverse payments. Those are payments that are made from a branded pharmaceutical to a generic, ostensibly for the purpose of keeping the generic off the market so that the branded prices can stay high. There have been a number of cases concerning that. And in the insurance realm, that's where you generally have these ERISA cases. For example, if there's a medical practice that is, or medical treatment that is not covered by the plan. I think that's where I'm going to stop for right now because I know we want to get into specific questions. There's other slides out there if the slides are to be handed out that you can look at your leisure.
Okay. So we had a prior meeting and we talked about a number of issues that we thought would be interesting to discuss here. The first one is, how does standing create conditions that affect the use and success of class actions in healthcare disputes? And we're going to start with Matt.
Well, again, standing is a very important issue in any suit, right? The plaintiff has to demonstrate that he, she, or it has a capacity to sue under the law. In the antitrust jurisprudence, in order to demonstrate that you have standing, you have to show two prongs. One is, were you injured in a manner that the antitrust laws were designed to prevent? I love that phrase because I still think that most people, including most judges, have no idea what it means. But in any event, you have to demonstrate that, in my view, the practice was somewhat targeted towards increasing prices to the constituency that's suing or potentially foreclosing competition to the entities that are suing. I will also say that in class action jurisprudence, from a standing perspective, it's very difficult for competitors in an antitrust case to sue as a class, particularly under Rule 23b3, potentially under B2 where you're seeking injunctive relief, but it's very difficult to sue under B3 because why one entity may have lost profits may be due to the anti-competitive practice, but another entity may have lost profits because it's got bad management. So there's much more of an individual inquiry there, so the predominance prong is not necessarily satisfied. Consumer suits, though, it's generally satisfied if you can show some type of regression analysis or other type of pricing analysis that demonstrates that there was an overcharge, or that, again, that you can prove that there was an overcharge or have common proof to try to prove that you can prove an overcharge at the jury phase. That's what you need to demonstrate. Finally, on the standing issue, I want to kick it to Colin because I know he's been patiently waiting. Under the antitrust laws, you have to show that you're an efficient enforcer of law, meaning that there's no other entity out there that is suing for the kind of damages that you're suing for. Sometimes you have suits brought by so-called direct purchasers under federal law and indirect purchasers brought under state law. You have that often in California. For example, I'll give you a pharmaceutical case. There was a case called In Re Lidoderm, which had to do with these reverse payments that I was mentioning, and there was a direct purchaser class and there was an indirect purchaser class. They were both satisfied and they both led to settlements. They both were claiming different types of damages, although of course the defendant argued that this was just a double recovery. At the end of the day, the defendant lost that argument. So I'll stop there and I'll kick it to Colin.
Great, thank you. So I'm going to present the defense perspective. So take my comments in that vein. Actually, I do, as Matt does, both sides of the equation. In fact, I met Matt many years ago working on a plaintiff side case as co-counsel with him, but by and large, I focus on the defense side. And to answer the question on standing, Matt started out by saying, there are antitrust cases, class action cases that are efficient. They're good because the overall overcharge is relatively small and you need to have a class. And that may be true, but the reality is, by and large, it's a business. Class actions are a racket, in my opinion, and that really it's designed effectively to get the lawyers paid, the plaintiff's lawyers paid. And how do you know that? Well, one of the things that they've been doing is they've been going to their named plaintiffs and they're saying, hey, look, if we win, if we extract a settlement from these defendants, we're going to have the court award to you personally hundreds of thousands of dollars in incentive payments. Okay? That's what they're doing. And so it shows that this is really nothing but a business. And so the question is, what do courts do to try to prevent these rackets from happening? And one of the things that they use, one of the tools that they use is standing. And under the federal antitrust laws, they say that you have to be, and I'll focus on basically consumer or purchaser class actions, you have to be the direct purchaser. You have to be the next person down in the line from the defendant in order to bring suit. And the Supreme Court decided that in the 1970s in a case called Illinois Brick. And a lot of states were unhappy with that, and about half the country was unhappy about that. And they passed these statutes called Illinois Brick Repealers. And those Illinois Brick Repealers, named after the Supreme Court case that said you have to be a direct purchaser, says, no, you don't have to be a direct purchaser. You can be anybody. As long as you got overcharged somewhere in the distribution chain, you can sue. And so you get to bring these cases as class actions under state law, and often you can bring them into federal court through CAFA or otherwise, but you're bringing it under state law, and you're basically covering about half the country. So now the question is, when you're filing a lawsuit or you're getting hit with a lawsuit, the question of standing comes up to play. And the question is, okay, if you're a direct purchaser, right, that's where the money is. Because the direct purchaser, as Matt says, all you have to do is hire some guy who will run a regression and say, hey, you were overcharged by 20%, and that's it.
Or gal.
Or gal, sorry. Yeah, you're overcharged by 20%, and then you're done. But if you're an indirect purchaser, well, already you're only talking about half the country, so you've already knocked down your damages by half. And then you have to prove not only was the direct purchaser overcharged, so that 20%, but how much of that direct purchaser overcharge was then passed on to the next level in the distribution chain. And then not only do you have to do that, you have to say, okay, if you're the second or third or fourth person in this distribution chain, and you figure out, okay, I was finally overcharged, instead of 20 cents, I was overcharged by 2 cents now because I'm the fourth person in the chain, I still have to go down the next level to the final level and say, was there somebody below me that got, that I was able to pass on some of that overcharge to? Let's say I was able to pass on 1 cent of that 2 cents that I was overcharged, 50%. Okay, so now you have a class that's initially worth 20 cents if you're a direct purchaser. Now it's worth 1 penny, so it's now 1 cent. And it's only half of that because it's only half the country, so now it's 50 cents. And then on top of that, you still have to show that you were entitled to bring it as a class. So that's all the predominance issues that Matt was talking about. So by the time you're done, you find out that while direct purchaser cases are often bet the business cases from a defense perspective, and they're worth a lot of money and worth a lot of effort, the indirect purchaser cases, if that's all there was, those are just nuisance cases. And so ultimately figuring out whether or not you have standing or not is important. And in the healthcare context, it's not always clear and it's not always easy to figure out who in fact is the direct purchaser. So you start thinking about the healthcare markets, and you've got GPOs, you've got distributors, you've got manufacturers, you've got pharmacy benefit manufacturers, you've got a whole bunch of different people in this ecosystem. You've got insurers, ERISA plans, you've got the patient. Who's the direct purchaser? Just think about for a second the manufacturer who sells a pharmaceutical product to a healthcare system, to a hospital, okay? But they purchase their products through distributors. The manufacturer will negotiate the end user price with the hospital, and they will ultimately take delivery. But the title goes through a distributor. Who's the direct purchaser? Is it the hospital or is it the distributor in that case? And do you need, if you're a plaintiff, do you need to have a hospital as your plaintiff, or do you need one of the very few distributors that are out there to be your plaintiff? And if you're not a distributor, you don't have a distributor, and they're the direct purchaser, then maybe you're out of luck. And this is actually a pretty tough question to answer. It's not even clear. And in fact, the Supreme Court is actually now addressing this exact question. We should have a decision in a couple of weeks.
Maybe today.
Maybe even today, yeah. Where the Supreme Court is asking the question, okay, Apple, which owns the platform, everybody buys their apps through Apple, but the app developer is the one that's actually setting the price, and Apple is collecting a commission. They're collecting 30% commission on all the revenues going through the App Store. Is Apple the direct seller, or is the app developer the direct seller? And if Apple is the direct seller, then the consumer class has standing, and they can bring a claim. But if the app developer is the actual purchaser, if you're actually buying from the app developer, the person that creates the game or whatever, then Apple is not a direct seller. It's an indirect, it's not the direct seller, it's indirect, it's further up in the chain. And so the consumer class has no standing to bring the case. The Supreme Court hasn't decided one way or the other which way that's going to come out. But they will, and once they do, it will change the landscape of whether or not you have a direct purchaser case that's worth something or an indirect purchaser case that's really worth nothing. And I'll stop there.
Can I just respond? Sorry.
Sure.
Now the gloves are off, so I can get a little bit more. I wasn't sure where Colin was going to go for this. So let me tell you why it's not a racket. Okay. There's 3 reasons why. One is that we have rule here in this country, Rule 23 of the Federal Rules of Civil Procedure. And the purpose of the rule is to do exactly what Colin said, is to allow for often small purchasers to bind together to seek justice that they otherwise would not be able to seek. I was involved with a case in front of Judge Rakoff last year where Judge Rakoff was dealing with the issue of arbitration clauses, and I know there's another panel on that, so I don't want to talk too much about that. But in talking about why he felt he had concerns over Supreme Court precedent concerning the enforceability of contracts of adhesion which had arbitration clauses, he talked about the Seventh Amendment jury right that people have in this country. That's part of the Constitution, to seek access for justice when a defendant has engaged in bad practices. That's the first thing. The second thing, Colin talked about how you have class actions where there are individuals who are paid off and given incentive payments. I believe that's true. But not all class actions are like that. That's why we have Rule 23, and you have to satisfy what the Supreme Court says with respect to predominance is a demanding standard. Often, you have entities bringing class actions, particularly in the healthcare sphere, that are as big as Oxford or United Healthcare. They're not being taken by the nose to bring the class action. My firm in the payments sphere brought a case where Walmart was the lead plaintiff, the largest merchant in the history of the world by that time. I can tell you that Walmart could push us around. We couldn't push them around, okay? The third thing is what Colin said about pass-on. He's absolutely right. In an indirect purchaser case, you definitely have to show pass-on. But sometimes, particularly with healthcare, pass-on can be almost 100%. There's been non-healthcare matters. One was concerning Qualcomm that's in front of Judge Koh, or was in front of Judge Koh. It's now in the Ninth Circuit, where she held there was effectively 87% pass-on. Health insurers in constructing premiums, when they're talking about overpriced providers, are generally passing all of that cost on. So indirect purchasers at times may have even larger claims than direct purchasers. I'll go with that.
Okay. So let me just, are there any questions about the standing issue from the audience? Okay, we'll move on to the next one. All right, so the next question has to do with the challenge of the proof of common impact in healthcare matters. And again, we'll start with Matt.
Well, so here, I think Colin talked about it, and I agree with him. Often in an overcharge matter, it's going to come down to some kind of econometric work demonstrating that there's an overcharge. And I also agree with Colin that, well, Colin didn't say this, but I'm assuming, I don't think all economists are equal. I've seen some pretty bad economist product out there, and I've seen some pretty stellar economist product out there. So there was a question as to whether or not the regression is actually robust and sufficient. In certain junctures, you'll have class economists say, well, I can do a regression analysis. I haven't done it yet, but I could do it, and that satisfies class. I don't believe that class satisfies class. I believe there should be some more rigor there, but that's definitely something that happens. The defendants often will say, no matter what you present, there's 100 reasons why, and Colin was talking about the health distribution chain before. It's too complex to come up with a common regression, and I see this as sort of the argument that I think about the Mets. You see, I'm a very dedicated and upset Mets fan, all right? The reality is I've talked to my friends about it. I've talked to my dad, who forced me to become a Mets fan my whole life, and said, why are the Mets so bad? And you'll have some of my friends say, well, if you look at sabermetrics, you can do regression analysis, you can look at, various different statistical studies, you'll figure out why they're bad. But the reason why they're bad is simple. They can't hit, they can't field, and they can't pitch. Okay? So that's sort of the argument. I know it's funny, but in some ways, the argument at these class stages is about the plaintiffs presenting a robust model, okay, and the defendants trying to attack it based on the diversity of distribution schemes, the level of verticals that you're talking about, and I think often the defendants overblow this, and that's why they'll sometimes fail at the class certification stage. It's not always easy for the defendants to attack that, but that's what they try to do. Lastly, I want to make sure we're on time.
You're good.
Lastly, one of the things I think is very important to discuss about common impact is this. The Rule 23 analysis is not a Rule 56 analysis. The plaintiffs are not moving for summary judgment. And sometimes there have been courts, particularly in conservative jurisdictions, that have said, well, you haven't proven that there's common impact at the class stage. That's not the test and cannot be the test. The test is, and this comes straight out of Comcast, which is a Supreme Court case. Have you identified common proof, a model that would allow you at the jury phase to demonstrate that all or nearly all class members have been harmed. Indeed, in some of these reverse payment cases, courts have held that even if there's up to 10 to 15% of the class members that weren't injured, so long as you can provide a mechanism that allows you to separate those class members that have not incurred injury, you're okay and you pass certification. And I, for one, believe that's meeting with the principles behind Rule 23, which again is to afford access to the courts.
Okay. So Colin.
Okay, so the question here is the economist expert report and whether or not they're able to show common impact. And the problem that we find is that courts are just not experts at dealing with it, because what you find out is when you get in under the hood of these expert reports, you find out that there's tricks all over the place. What you find is that there's actually embedded assumptions that assume the existence of class impact instead of proving it, and that's the problem. Unlike what Matt says, actually proving and getting a class certified, even in a direct purchaser case, is not easy, particularly in healthcare cases. And the reason that it's difficult in healthcare cases is because healthcare cases typically are cases that involve some element of competitive foreclosure. You're pay for delay, you're delaying generic entry, you're engaged in monopolistic, exclusive dealing, bundled rebates, rebate walls, some people call them, to lock out competitors from the market, even ones that, even branded competitors that have been approved. You use various anti-competitive practices to keep them from the marketplace. That's very different than price-fixing cases. When you have a price-fixing case, you have two competitors getting together and they say, oh, we're going to fix the price, we're going to fix the list price, and that's the price we're going to charge. And even if we don't charge it, we'll just have some formula, some discounts, formulaic discounts, and everybody will get the same discounts, and that'll be that. And in those cases, it's easy to show common impact because you have a formula. You have an underlying inherent formula, and all you got to do is identify the formula, and it just sort of, the cloud's clear, and you can see, okay, this is how much everybody was overcharged. And if you inflate the list price, then everybody else's prices also got inflated by that same amount, according to that same formula. Rising tide lifts all boats is what they used to call it. So in those cases, it's easy, but in healthcare cases, it's not like that. In healthcare cases, you don't conspire to fix the list prices. You're somehow driving somebody from the market, and what the impact on prices are is very unclear, and whether it impacts everybody the same is very unclear. And that's sort of the critical thing, because it used to be, as Matt says, it used to be that economists would come in and say, I haven't done a regression, but I could do a regression, and all I got to do is show that some regression at some point is going to show some impact. And courts would say, yeah, that's true, that's fine, you can come up with some regression. I haven't seen it yet, but I'll take it on faith that you'll be able to show common impact. And the reason courts did that was because there was actually the rule, the federal rule, back in from 1990s to 2002 or so, had a rule that said class determinations had to be made as soon as practicable. And everybody thought that had to be made even before real discovery took place. And so effectively, class certification was getting decided under effectively a pleading standard. And that meant that there were presumptions that said that we're going to resolve doubts in favor of class certification. We're not going to resolve battles of the experts. We're not going to allow discovery. We're just going to require that the plaintiff show some method that's capable of proving class impact. In 2003, the rule was amended. So it was no longer that courts had to decide class certification as soon as practicable. Now they have to decide it at an early practicable time. And everybody thinks, well, that's the same, but it's not. What that meant was that courts now had discretion to put class certification after discovery. And courts, recognizing that, started to decide cases like hydrogen peroxide is the main case in the Third Circuit, and all the cases that sort of followed, including Comcast and others, to say, okay, now you have to do a rigorous analysis. So presumptions are out, not presenting declining to resolve battles of the experts are out, declining to engage in fact-finding is all out. What's in is a rigorous analysis, and you have to prove, if you're a plaintiff, you have to prove that you can show common impact, and you have to prove it by preponderance of the evidence. So Matt is right, it's not a Rule 56 standard. It's actually higher than Rule 56, because Rule 56 does not allow the court to engage in any fact-finding. It just has to decide, is there a genuine issue of material dispute? That's it. That's a very low standard for a plaintiff to get over. But in the class context, they have to show by a preponderance of the evidence that every class member was injured. And they have to show that their regression is capable of doing it. So how do class plaintiffs do that? Well, and I said that there were tricks. I started out by saying class plaintiffs have tricks. What they do is they've taken what used to be called the Boghossian shortcut. That's that two-stage process that I was talking about, where they say in a list price, if you have a conspiracy to fix list prices, you show first that there is a list price, and that all prices are determined by formula off of the list price, discounts off of list price, and it's all formulaic. And then you use a regression and say the regression inflated list prices by an average amount of X, 20% or whatever. And when you combine step one, a rigid price structure, with step two, an average overcharge, you have common impact for all class members. And that was what was called the Boghossian shortcut. Plaintiffs didn't like that because it had the word shortcut in it, and in hydrogen peroxide, you can't have presumptions or shortcuts. So they got rid of the name, but they still use the two-step process. They say you need to have a rigid price structure followed by a regression analysis. The problem is when you get into healthcare markets, you don't have the rigid price structure anymore. What you have is you have very large companies, health systems and others, doing a lot of individual negotiations. And individual negotiations are anathema to class certification. You can't have common impact if you have a lot of individual negotiations. So what did plaintiffs do? Plaintiffs said, oh, well, no worries. I'll just use my economist regression, and my economist regression will show not just an average overcharge, it'll show what every class member's overcharge was, because a regression can predict a price. And so I'll just predict what every class member's price was, and if they paid more than that, they were injured. That's how they use the regression, okay? But in fact, a regression can't do that. What plaintiffs are doing is they're taking the error term of a regression, that is, the fact that the regression is incapable of actually showing anything with certainty, so there's an error term, and they're saying if that error term is small enough, then everybody was injured. If it's big enough, then it's not. But built into that regression is the assumption that there is a rigid price structure. And if you get rid of the assumption that there's a rigid price structure, that there would be an average price, that everybody would pay exactly the same thing, this average predicted price, if you get rid of that assumption, then there's no common impact. So ultimately, and we'll have to see, we had a case that ultimately settled before this case was decided. It was briefed up and it settled right before the judge ruled on this issue. But ultimately, that's going to be the next battlefront, is can a regression actually show individual impact or common impact in the absence of a rigid price structure? And that's the next battlefront. And I suspect that if you can get a court to actually pay attention, they will find that in healthcare markets, for the most part, there is no common impact.
Just quick responses. Maybe Colin should go first next time so he can respond to me, because I think this is unfair. But
Okay,
so
we'll
I'm being Colin's lawyer at the same time that I'm criticizing him. In any event, the reality is no, Colin makes points that are definitely what the defense bar would put forward. So that's their arguments. But I will say a few things. First of all, the idea that a rigorous analysis had to be done, that's from a case called Falcone from the 70s. Nothing changed in 2003. Okay, that's the first thing. Secondly, that you can't have class actions where there's some degree of foreclosure. There's been certifications in healthcare cases, particularly in the reverse payment cases, all over the place. Lidoderm, Nexium. There's been several other cases like that. In the Mesner case that I mentioned, the post-merger price increase in the Seventh Circuit, David Dranow, a renowned economist who was the FTC's head of economics, he came up with the regressions demonstrating how you can have a price increase that was for all types of products that the hospitals provided, all services, whether it was neurosurgery or Band-Aids, okay? And that passed certification stage. The standard, when I said Rule 56, I was talking about the plaintiffs being the movant. And when a plaintiff would move for summary judgment, the plaintiff has that burden of showing there's no material issue of fact. Not when they're opposing summary judgment. So no, Rule 23 is not a higher standard than what a proponent would have to prove on a Rule 56 motion. Indeed, again, the Comcast case says what it says, and you do not have to prove at the class stage that each and every member of the class have been harmed. The courts are uniform, that you have to show that there's a mechanism for demonstrating that, so you do not take that out of the hands of the jury. Finally, on this regression argument that Colin's making, I think this is where you're getting into specifics. I think you're getting into, I can tell you that I've been involved with cases in healthcare where, in particular, the issue is how stable is the pricing and what has happened with the pricing. And the reality is in healthcare, we have enormous amounts of data, paid claims data, premium data, Medicare data filed with the states. There is so much data out there that economists can use to demonstrate price stability. Now, there's a lot of economists out there, I think, that don't do that and try to take a shortcut. I'll submit that. Don't certify a class there. But don't throw out the baby with the bathwater. You don't throw out all classes because certain economists can't certify the test. Finally, last on foreclosure. Foreclosure cases have been certified, not only in the context of the reverse payments, because again, what's there? You're proving that there was a price that wasn't constrained because a low-price competitor wasn't put on the market. It's been done in other contexts as well. The Visa MasterCard cases that we litigated was all about Visa foreclosing ATM networks from competing with it due to its tying arrangement. They charged 12 times what their competitors charged, and they were able to do that by forcing merchants like Walmart and the corner store here on 60th Street to accept Visa and MasterCard debit transactions. That resulted in a $3.4 billion settlement after class certification was granted and summary judgment for the defendants was denied. So there you go.
Okay. Do you have a response?
When you look at it, so he brought in Visa, MasterCard. When you look at it, they have a rule book that's like this thick. And if you're talking about proving a formulaic impact, well, you just look at the rule book. The rule book tells you what every merchant is going to pay. Okay, so it's not that hard to figure out that there's going to be common impact because you just have to look at the effect of the challenge rule on that rule book. But in the healthcare markets, it's completely different. In healthcare markets, there's individual negotiations. Prices are actually between a buyer and a seller. There are certain formulaic discounts, but on top of that, there's a lot of discretion that companies have to set prices. So if you think about, selling, your box of gloves, to the independent physician, who sets that price? Is it the manufacturer of the gloves? No, it's the distributor. How does the distributor set the price? Well, they have a catalog price, but then they have a series of 1,000 sales force people going out to the doctor's office every day and having a lot of discretion to set price. And in that context, you have too much individual variability to say that there is a rigid price structure. And once you don't have that rigid price structure that you had in Visa and MasterCard, then you're in a world where you need to show that there was individual impact, and a regression can't do it. A regression can assume there was individual impact, it can assume common impact, but it cannot show that there was common impact. For that, you need a rigid price structure, and a lot of these cases don't have it. And that's why these cases fail. So when we get to the next question, we'll
All right, but
I got to do one answer. One answer on the rigidity of the price structure. I would submit, go talk to any actuary, any healthcare actuary, and ask them, is there a formula that is utilized for deriving the premiums? And they will tell you absolutely, particularly because of the standards that have been imposed on them by the Affordable Care Act. So I just throw that out for your consideration. Anyway.
Well, I'm going to actually ask a question now. I think that the insurance a part of this supply chain is very different, because in the insurance aspect, one thing that does go on, and I'm going to drop this down from the large insurers that are self-insuring and talk about the various companies that are buying insurance and are not self-insuring, but they're all pooled. So if there's anything going on in your healthcare system that is leading to overcharges, unlike a market where you're buying hammers, for example, and you buy a hammer, I buy a hammer, we're not linked, we're not joined at the hip. When you go in and have surgery, whether or not I have any surgery at all, we are linked. And so the insurance setup actually pools all of your buyers together in their pooled risk. And those healthcare expenditures, it really doesn't matter if it only needs to happen for one, because when it happens for one, it happens for all. So I think that is a very different situation.
So it's different, but it goes back to the very first question of standing. In most cases, the insurer is not the direct purchaser. They're somewhere down the chain, and they're not the ones setting the prices. And when they do set the prices, for example, when they're negotiating with the hospital, for example, every hospital has very different prices with every different insurer, than everyone else. There's a lot of individual negotiation that takes place, and therefore, even though at some level, at the insurance, at the patient pool level, the insurer gets some common, figures out how to diversify its portfolio, like you were talking about in the first thing, you got to diversify the portfolio, doesn't mean that every person that bought something somehow got overcharged at all.
I agree with Colin on the standing issue. I mean, particularly if you're talking about an antitrust case and you're talking about, for example, provider market power. And I will submit that one of my issues as an American citizen and the cost of healthcare comes down to provider market power and how do you discipline these entities through litigation? And one of my what I know happens is that the way insurers calculate rates is even if they individually negotiate with hospitals or with providers, what they do is they take their medical care expenses, and as Robin said, they average it out on a per member per month basis for all their members. So that's what feeds in the premiums. Medical expenses on an average basis, administration fee on an average basis, and profit. That's it. That's how you come up with a premium. So it's quite formulaic. Now there is an issue of standing. So I would argue that if you're going to bring cases under the antitrust laws for damages, not necessarily for injunctive relief, but for damages, you may have a tough time if you're going to try to litigate about provider market power. But under state laws like the Cartwright Act in California and other state laws, which are, as Colin said, are Illinois repealer jurisdictions, you'll have a better shot. So I think this is something that is of importance, particularly when you consider that it seems that there's bipartisan thought here that in our health environment in the United States, we pay way too much for too little. You pay about 4 times as much as you pay in Japan, and we live 10 years younger. So this is an issue that needs to be dealt with on a policy basis, and I believe on a litigation basis as well.
Okay, and we're going to go on to the next question from there. So the next question is really focusing on in healthcare. There's an extremely high rate of innovation, transformation of the products, and there are many products and services that are not currently on the market. And the question is, how do those products and services not currently on the market affect the use of the class action device going forward? And I'm going to start with Colin this time.
I agree.
Okay. So as I was mentioning just before, was that foreclosure cases are very different. So when you're talking about a product, when you're talking about innovation in healthcare, a lot of the anti-competitive conduct is really designed, how do you prevent the next best thing from coming onto the market, or how do you prevent the next cheapest thing, the cheaper version of it, from coming onto the market, pay for delay and whatever. And those cases are very different because than price fixing cases, because what you have is you have a situation where you have to estimate what would the effect be when somebody else comes into the market, and would it impact every type of customer the same? I mean, would it impact the large health systems the same as the small individual practitioner, the solo practitioner? Would it affect the retail pharmacy the same way that it affects the health system, the consumer? And so that ends up being a big problem. And when you think about it, Matt was saying there are lots of cases that have classes certified, and you can see the Lidoderm case, the Nexium case, you can see that. But there was another case after Nexium in the First Circuit. It's the Asacol case that basically overruled Nexium. It didn't say that it was doing it, but that's what it did. And what it said was, hey, look, you can't show that every class member was injured. And why was that? Well, that's again because healthcare is very unique. That case was, again, a pay-for-delay case where you're preventing generic entry. And you say, oh, well, you're preventing generic entry. Well, obviously, prices are going to come down, and pretty much that's going to impact everybody. There might be some outliers, but that's going to affect everybody. That was the argument. But it's not the case. Because what happens in pharmaceutical markets? Well, before there's a generic entrant in there, there's the brand. It's a sole source. It's a monopolist, no question about it. And so what does the monopolist do? Well, it has to sell to all customers. And there are price-sensitive customers that only want to, will only pay the cheap price, and there are customers that really need the product and are willing to pay a lot. And so there's price-sensitive and price-insensitive customers. And what does a monopolist do when it faces that situation and it can't price discriminate? It charges sort of a blended rate. And that's what branded companies do. But when a generic comes into the market, it sort of bifurcates the market. The generic takes all the price-insensitive customers, and the brand keeps all the price-sensitive. The generic takes all the price-sensitive customers, and the brand takes all the insensitive customers. So the branded price actually goes up. So unlike most markets where when you have an entrant come into the market, it lowers the price, it comes in below the incumbent, and the incumbent lowers prices to continue to compete. The opposite happens in healthcare markets. The branded price actually goes up. What does that mean? Well, that means that any customer, any patient that would have continued to purchase the branded product even after the generic entrant comes out was not injured. And there are a lot of people that would continue to buy the branded product. Usually it's about 10 to 15% of the market is going to continue to buy the branded product. And so going in, their regressions will even show it, about 10 to 15% of the market of the defined class, will not be injured. And what the First Circuit said in this Asocol case was it said, look, if you have 10 to 15, well, there it was 10%. If you have 10%, then you haven't shown that all or virtually all class members, which is the standard, have been injured. You haven't shown that, and you can't show it. And you can't show it on a class basis. And the plaintiffs came in and said, well, in Nexium, we face the same problem, and you let that case go forward. We said we just deal with it in the class administration phase. We just send out with the class notice a declaration that everybody would sign, and you say, are you a class member? Would you buy the generic or would you buy the branded? And if they say we buy the generic, then they're in the class, and if they're not, then we can exclude them.
I'm gonna move on because I'm
Okay.
getting a sign
Oh,
here.
okay.
And I want to make sure that Matt has an opportunity to respond to this one.
So Ascol did not overrule Nexium, but as Colin was getting at, in that case, they did not come forward with a mechanism for figuring out how would you demonstrate that there were uninjured class members. And I'd also say from a policy standpoint, this is a defense argument that should be thrown out. Here we know the FTC had litigated that indeed that there was a settlement that kept branded prices high. And the fact that arguments are being brought that say, well, I would pay the high price anyway when you could have paid a lower price. Look, I love going to the Met games, okay? But I'd rather pay $20 for the Mets ticket than $40. And anyone who would say, I'd pay $40 anyway, even though they're terrible, because I would get so much enjoyment out of it, that to me is a silly argument, and I don't think it should be accepted in any event. That's one thing. Secondly, I just want to talk about, again, what these foreclosure cases demonstrate. By keeping lower prices off the market, and that's the type of innovative products that Robin was talking about. Think about insurance products. There are certain insurance products out there that are lower priced on purpose. They might be high deductible products, or they might be products that offer narrower networks, so that somebody who has a choice between a broad network and paying higher prices or a narrow network and paying lower prices would choose the lower product, the lower price product. If they're excluded from the market, that's going to keep other prices high for the existing products because they're not going to have the same economic constraint. In that situation, those that have continued to buy the existing products are overcharged, and that's the theory. Lastly, I just want to say one thing that's not subject to antitrust but is subject to ERISA, and again comes up with these experimental treatments. Innovation in healthcare markets doesn't just come in the form of pricing of insurance products, but obviously of medical treatments. And sometimes you'll have new medical treatments that insurers don't want to pay for, but certain members think they should be able to get. I litigated a case like that, not in the class context, but concerning MRIs. And I would say, from an antitrust perspective, that case probably wasn't certifiable. But from an ERISA context, when you're talking about does the insurance policy or should the insurance policy cover this new type of MRI, that to me seems to be something that is endemic to all class or all plan subscribers or plan members and can be litigated on a class basis.
Okay. And it seems like we are out of time. So I think are we getting a break now? We have a break. And so if you have questions, please, I invite you to come and ask questions. Thank you very much. Okay, thank you guys.
Thank
That
you.
was terrific.
Thanks, Robin.